Serving as an executor in Texas isn't just about following the will, it's about making sure the law is followed every step of the way. In part 2 of our series about the top 10 questions of executor duties in Texas, I'm covering the next 5 questions I frequently hear. I'm Jennifer Nichols with Nichols Law. In part 1, we talk about the first 5 duties of an executor in Texas, from notifying the beneficiaries and creditors to filing an inventory with the court. If you missed that video, go back and watch it after this one. Today, we're finishing the list with questions 6 through 10. Let's dive in. Question number 6. How does the executor handle paying debts and expenses of the estate? First, the executor needs to go through the process of notifying creditors set forth in the Texas Estates Code, discussed in Part 1. If an unsecured creditor does not file a proper claim within 120 days of receiving the permissive notice described in Part 1, the claim is barred. Assuming proper claims are filed and there are sufficient funds in the estate, the claims should be paid before the assets are distributed. Some assets may need to be sold in order to create funds to pay the claims. If there are insufficient funds in the estate to pay all the properly filed claims, they get paid based on a priority. Unpaid federal income taxes owed have first priority. The rest of the claims are to be paid based on a priority set out in the Texas Estates Code. The payment priority is as follows: funeral and last illness expenses up to $15,000 each, administration costs, which are attorney and court fees and executor compensation, secured debts, mortgage, car loans, child support arrears, taxes and government debts, Medicaid estate recovery, other unsecured debts such as credit cards, personal loans. It is very important that the executor pay properly filed claims in accordance with this priority. Otherwise, he or she could be held personally liable. Question number 7. Is the executor responsible for filing tax returns and paying taxes? The answer is yes. Executors must make sure the deceased person's final income tax return and any unfiled prior returns are filed. All federal income taxes owed should be paid before paying any other claims of the estate. If the estate generates more than $600 in income, the executor must also file an income tax return on behalf of the estate. If tax is owed and income is distributed to a beneficiary, the beneficiary will be obligated to pay the tax on the taxable income. If the income was not distributed, the executor will need to pay the tax out of the assets in the estate. In addition, if the gross estate plus lifetime taxable gifts exceeds the federal estate tax exemption, which is $13.99 million in 2025, the executor must also file an estate tax return on behalf of the estate. The executor is responsible for paying any estate taxes owed out of the estate. Question 8. Can an executor sell estate property without the beneficiary's consent? In Texas, an executor can generally sell estate property without the beneficiary's consent. In many cases, the will specifically grants this authority to the executor. In this case, the executor can sell estate property even if it's not necessary to pay debts, expenses, or taxes. Even if the will does not specifically grant authority to sell, as long as it provides for an independent administration, then the executor has authority to sell property if necessary to pay debts, expenses, or taxes. If the will does not grant the executor the authority to sell and does not provide for independent administration, the executor can apply with the court for authority to sell property to pay debts, expenses, and taxes. However, if the will specifically devises the property to a beneficiary, the executor is obligated to sell other property first and only sell the specifically devised property if necessary to pay claims. Importantly, you should check with your attorney before making any moves to sell property. Question 9. How does the executor allocate assets among the beneficiaries? In Texas, once all valid debts, taxes, and expenses are paid, the executor distributes the remaining probate assets among the beneficiaries according to the will's instructions. If the will designates specific assets, such as my house goes to Alice, the executor must follow those directives exactly. For assets not expressly designated in the will, the executor is tasked with allocating them among the beneficiaries as directed by the residuary clause. An example of a residuary clause is, I give all the rest, residue, and remainder of my estate to my children in equal shares. In these situations, the executor may use their discretion to make fair allocations, but must still comply with the will's overall intent and proportional shares. The executor should value all residual assets and make distributions, sometimes through liquidation and division of proceeds, or occasionally by dividing the actual items if agreed by the beneficiaries. If disputes arise over specific items, the executor should encourage the beneficiaries to agree on an allocation, but may use professional appraisals if necessary to achieve fairness. If an executor has questions or needs help allocating assets among beneficiaries, they should reach out to their probate attorney for assistance. Question 10. What fees or compensation is an executor entitled in Texas? The answer to this question is it depends. If the will specifically provides that the executor is not entitled to compensation or provides a different method of calculation, those instructions control. This means the executor may not receive statutory compensation. If the will does not address compensation or says that the executor is entitled to reasonable compensation, then Texas Estates Code, Section 352.002 comes into play. Under Texas Estates Code, Section 352.002, an executor is entitled to a standard fee of 5% of all cash received and 5% of all cash paid out during administration, excluding money on hand at death in bank accounts, CDs, money markets, life insurance proceeds paid directly to beneficiaries, cash distributions to heirs or legatees. Texas Estates Code Section 352.003 provides for alternate reasonable compensation if the statutory fee is unreasonably low, such as if the executor managed difficult business assets or performed extraordinary effort. The court may increase, reduce, or deny compensation if the executor's performance or circumstances warrants it. Importantly, an executor can always waive compensation, and often does, if they are a beneficiary under the will. And that's it. The top 10 questions about executor duties in Texas. Between parts 1 and 2, you now have a clear roadmap about what an executor is expected to do under Texas law. If you've been named as an executor and need assistance seeking admittance of the will to probate and issuance of letters testamentary, reach out to us at Nichols Law. We'll guide you through the process and make sure every detail is handled properly. And don't forget, subscribe, follow us on Facebook, and share this series with someone who could benefit from it.